Of our continued efforts to reach the African and other ethnic communities in the United Kingdom with greater impacts and create the platform to hear your silent and unheard views in this hugely growing community in the United Kingdom, our channel Ben TV presents to you another live current affairs television program. Our focus on the program is to review and discuss issues around the diaspora community in the UK. The program offers you that unrestricted voice on issues affecting you in the UK. Join us live every Monday at 10 a.m. to 12 noon. Another business segment of Dialogue in Diaspora, 2 to 3 p.m. every Monday. But guess what? You can be part of the program. Just send us an email at bentelevisionuk@gmail.com. Dialogue in Diaspora, your voice, your opinion on our TV. Well, thank you for joining us on this program of Voice coming to you from Ben Television. My name is Today Alabi. This very episode of Voice should be taking a look at Brexit and, of course, what it does mean. We have been looking at this topic for some time now, but the thing we need to look at today, just recently, the British Prime Minister, Mrs. Theresa May, did say that low-skilled workers from Europe would have to obtain work permit to remain and work in the United Kingdom. What does this mean? If you are from Europe and you are in the United Kingdom at the moment, as soon as Article 50 is triggered, you may have to get probably we don't know what the law will say how this is going to go, but this is what we're going to be looking at on the program today. What does a work permit mean for low-skilled workers that are going to be working and living and staying in the United Kingdom if they are from Europe? This is what we'll be looking at on the program today. And also taking a look at the position of Commonwealth. There is this news going all around the social media that Commonwealth citizens, especially people from Ghana, Nigeria, and other Commonwealth countries, may no longer require a visa to come into the UK. How true is this? We have learned that people are paying huge amount of money to solicit kind of legal support or to get protected as Commonwealth citizens. We're going to be reviewing this case on the show today. My name is Tudelawi. This is your community legal talk show. This is a program we'll bring you information about legal matters to our community and how it does affect our community. And our partner on the program today, join us, is the senior partner at Obaseki Solicitors based here in the United Kingdom, Jennifer Obaseki. Jennifer, join us on the program today. Jennifer, thank you for being part of the program.
My
today.
pleasure.
Months now after Brexit, we still keep talking about Brexit, but nothing has actually changed. But the one information we do know is lately the Prime Minister did say that any low-skilled worker coming to work in the United Kingdom, as soon as Brexit becomes Brexit, they will require a work permit. Talk us through this. What will this mean? Bear in mind that most Europeans in the UK working are low-skilled workers. What does it mean for those that are here and those that are coming?
Once the UK enacts Article 50, which will confirm its decision to be leaving the EU, it will mean that the UK's legislation to cover all areas, including immigration, must be in place because the European law and rights and free movement of workers will not be in place. However, Britain is yet to negotiate its way out of Europe, meaning Britain is yet to outline what model it is going to use, whether it's going to be the Swiss model, the Norwegian model, which are these countries that are not member states of the EU but have a relationship allowing free movement of workers in and out of their country and reciprocal arrangements for their own citizens. So, depending on the UK's negotiation will determine how it will receive foreign workers. However, Theresa May has started to give us little snippets of information. The one that you've mentioned being that low-skilled workers will need to apply for work permits. As it is, the UK allows a certain amount of seasonal workers and people allowed into the country under its work permits programs. These are systems where, under the UK immigration rules and legislation, not the European, that people can apply to come into the United Kingdom to carry out certain types of work. There are domestic workers that are allowed to have levels of work permit, but they have to travel with a foreign national that is coming into the UK for a period. Then you have, as I said, seasonal workers and other foreign workers who may be attached to companies. What the UK is proposing is a more or less a points-based system where if you're coming in, you do not have a certain level of qualification, but yet you have other attributes, you'll be scored and then you'll be allowed to come in for a period and carry out work. How that assessment is going to take place, the scoring, the criteria is all yet to be determined. All Theresa May has done is give us a little drop. But what is going to follow, there's going to have to be a lot of negotiation, a clear program as to what will amount to a low-skilled worker, the full definition, the time period, the assessment criteria, etc. The UK relies heavily on low-skilled workers, whether it's helping to pick fruit, vegetables in factories, and they have been a driving force behind the economy and the economic, let's say, growth following the breakdown of the economy in 2008. So, in order to maintain these workers that are highly needed, this work permit scheme has to be concluded quite quickly. However, it's going to take 2 years, remember that, for the UK to effectively phase out the European legislation, put in place the legislation, the UK-based legislation that's going to replace the EU rules and regulations. And it's not going to be just as simple as that. There are going to be people who are going to maybe challenge the new things that come into place and what is outgoing. So how do people protect themselves? Number one, we cannot guess, but we can say those who are here, and we've repeatedly said it, if you are here and you're an EA national and you have not applied for your resident permit, please do so. If you have not applied for your proper residence permit, because many people sit down and say, oh, I've got my identity card from my home country, I've got my passport, I don't need to apply for a permit to say that I'm in the UK working. I don't know whether it's because they don't want to spend the money. One of the reasons that I know is because the form is very long and it puts people off. But now more than ever, you have to make that application so that before the changes come into place, you have secured yourself, you have anchored yourself, you have confirmed that you consider the UK as your country of residence where you're exercising your treaty right. On the other hand, many people feel a bit upset and go home, have gone home. And later, after going back to their home country, they may want to come back in. And at the moment, they can still move freely. But before there are the changes, they've got to really make that decision. So if you know that you're going to remain here, please fill out the application. And there are many places that can help you. If you go online to your, if you Google, find me a solicitor, you'll find immigration practitioners that are specialists in your area. So please, don't restrict yourself. Don't limit yourself or give yourself less of an option once, or wait till it's too late and changes come into place and you're adversely affected, negatively affected. Get the registration now, get your permanent residence now, and then it's up to you after the whole Brexit within 2 years passes, whether you want to leave, then you can do so freely.
I know we've spoken about this a couple of times, but quickly let's recap. What does it require for people, Europeans in the UK, to have the resident permit?
You should be exercising your treaty right. Obviously, you have to be from another European country or from an accession country. You need to be seeking work or engaged in an economic activity. So that means you can be employed, self-employed, working part-time. It's not necessary that you have to be in a high-paid job. You can be seeking work. You can be founding a business. And you can be studying. You can also be disabled and not in work. So again, look at your situation. If you're not sure, get some advice. Don't just think you can't apply for it. And then also think about your family members, your dependent family members. Those who are going to remain here with you, equally, make sure they apply for their residence permits as well. If they're non-EEA family members, it's more than important now than ever not to wait. If you've been refused in the past, reapply, get some advice, make sure you do it properly and sort everybody out before it becomes a bit too late.
In terms of time frame, do you have to have been in the UK for as a he national for a period of time before you can apply for your
the residence permit? You have to have enough evidence to show that you are here working and carrying out an economic activity. If you're not able to work because of disability or any other reason, it may be difficult. Again, you have to think about showing that you are habitually resident.
That you must have been there for 2 years, 1 year, 6 months.
It's not up to even the 6 months, you see. You have to be here, I would say, showing a level of 3 months wage slips and showing that you have a place of residence, an address, is what's important. Showing that you've been here for up to 6 months is not necessary. But what the Home Office is looking for is that the UK is your principal place of residence and economic activity. It's not that you're spending 2/3 of the year outside the country and 1/3 of the year in the country. You are actually here paying tax, working, registered as self-employed, paying NI contributions, and also having your level of health cover if you need it. So those are the key things that the Home Office is looking for, as well as your passport. You can't make these applications if you're a dependent without a passport or ID, and if you're a main applicant without one of the two.
If you are a dependent, say somebody from a non-EA country who is a dependent of who is married, what process would they require to also have their resident permit? Is it the same process?
And what's so important is people, relationships are up and down. So it's more important than ever that if you are depending on an EEA national and that person has not filed the correct paperwork, that you insist that it be done now before the changes. So some people have done maybe an attempted application, not had all their paperwork in place and been refused. Some appealed, been refused. Get the correct advice. Don't DIY your future if it's this important. Get the correct advice. Let somebody who's qualified and experienced put you through and get it done in the right way. If you're a non-EEA national, it's more important now than ever, because at the end of the day, you can only exercise your retained rights. So if your relationship breaks down in the future, and hopefully we don't pray for that, but it happens, you have to have been with your EEA partner for more than 3 years, have evidence that they were exercising their treaty rights. That's the main EEA national. You have to show that. And if you've spent years not putting in an application, just hanging on there, waiting for them to do it, it's not to your advantage. It's going to go against you very badly. And even if you manage to do the application, and let's say you get your 5 years dependency granted to you, but the relationship breaks down somewhere along the way. In order for you to have your retained rights of residence, that is the right to later claim your permanent residency in the UK, your settled status, you have to show that the relationship lasted for more than the 3 years. You have to show that the main applicant was exercising their treaty rights during that period of time. And if you can't, you may have to switch out of that category into another category that you may qualify for. Now, many people think, let me just put forward some wage slips to show that they were working for some part of that. Most people just think 3 years, let me show they were working for part of it, let me show that we were together. Whereas the standard of evidence is so high that may not be sufficient. And when people get refused for their permanent residence, thinking, but I did my divorce after 3 years, I showed that my EEA partner was working for some of the time, it's not enough. The Home Office want to see something for almost every month out of those 3 years. Just to show some wage slips or a P60 here and there or a P45 is insufficient. So you've got to get it right. It may be the case that you put in the application, get refused, and may, because of family life, get an appeal and allow that appeal be allowed to be heard in country. However, the Home Office is pushing for out-of-country appeals more and more and more. So even as an EEA person, a national, and an EEA dependent, If you're refused, your right of appeal may have to be exercised from outside the UK. It's becoming that difficult. So unless there are human rights reasons why that you shouldn't be removed, or it's going to be an immediate breach, you may not be successful in arguing your in-country right of appeal. Getting it right is now more important than ever, especially if your case has issues around EEA treaty rights or EEA-based applications. Again, if you're not a direct family member and you're an extended family member, step-sibling, unmarried partner, ex-partner, yes, if you are dependent on somebody and that person is, let's say, not a nuclear family member, so not a sibling parent, but is an extended family member, or you are just what we would say back home, a compound relative, if that is the case, then you can still put in your applications, because the rules and the EEA regulations allow for extended family relatives. So you have to then show the years of dependency and explain why you are so dependent on that person. Again, it may be due to a historical family pattern of support. It may be due to the fact that you were there's a family promise or a bit, an arrangement of some sorts, but you have to demonstrate it. You have to be able to evidence it. And many people suddenly think that they can come into the country or been here unlawfully and think, okay, I've got that Irish cousin from somewhere. Maybe now that I've been overstaying for years, I can go and depend on that person. No, you have to show that before you arrived here, there was a level of dependency on that Irish cousin. So again, it's all about taking advice, getting it right, putting in the application. If your evidence has not been strong, deciding whether you're going to make a fresh application or argue a right of appeal. And as much as I am, an avid person that defends the UK justice system, I must say immigration appeals can take now over 6 months to be listed. And during that time, due to the financial pressures on families, many are not waiting for the appeal, but just putting in a fresh application. Because you can imagine 6 months with no evidence to show that you can work can cripple a family. And the delay in applications is one thing, but now the delays in appeals is another. It's really quite arduous on some families that are waiting 9 months just for a hearing date, and over a year for their case to be listed. During that time, if there's restrictions on the main person or any other family members working, it is very, very tough indeed.
Okay, all right, Jennifer. I know people have actually said something about, emphasis has been on EEA nationals in the United Kingdom. What about EEA national outside United Kingdom? What is their fate? But our emphasis is basically about our community here in the United Kingdom. That's what we're looking at. And if you do require more information, you can get in touch with your local solicitor, legal advisor, or citizens advice bureau, or better still, you can get in touch with Jennifer or Basiki on the number that is scrolling on the screen. Will be able to offer you a piece of support and advice as we can on the program. We are still on Voice, where we take a look at legal matter and how our community can benefit from some of the issues arising on legal space in the United Kingdom. Jennifer, quickly before we round up the program, the issue of Commonwealth. I know we've spoken a couple of times about Commonwealth citizens in the United Kingdom, their right to stay, and what Brexit actually means for them. But there's this news going on around social media that Commonwealth citizens now do not no longer require visa to come to the United Kingdom. How true is this information that Commonwealth citizens now in the UK or outside the UK do not need visas? They're just qualified to be a resident as long as they're Commonwealth citizens.
I have a word that I like to use, which is nonsense. To nip it in the bud, nonsense. Please don't be fooled by these people that are sending out these things across Facebook, WhatsApp, and other social media platforms. They are doing it to fish for people who are desperate, and they are unscrupulous fraudsters. that are fishing for people who are desperate. They know people who have overstayed or are here illegally or that have been refused one way or another, that may come from, are most likely to come from a Commonwealth country, and they are just simply preying on people's desperation.
Advice: do you need professional help at a reasonable cost? At Obaseki Solicitors we have experts in property law, human rights, criminal litigation, immigration, civil litigation, family law, business law, landlord and tenant law, employment law, Sharia law. At Obaseki Solicitors, we can provide you with advice and assistance at all levels. We have over 100 years experience in serving our local communities, and we have a new maritime and international law department. We can help you. Book a free consultation today. Obaseki Solicitors, providing you with advice and assistance at
So giving them false hope, false news. Then when you meet these people, if you manage to, they will convince you to give them your last penny on this false hope. So the fake Commonwealth scheme telling people that you will no longer need a visa to stay in the UK, there's going to be privileges for you under Brexit. Theresa May hasn't said that yet. Boris said that he may do an amnesty. So the may do an amnesty, there is a legitimate petition that you can sign up to. I think that's done by 38 Degrees. So if you search online for the petition, that's a free registration for your petition in support of the UK granting an amnesty to people who have overstayed in the United Kingdom and those who are here illegally. The terms of any amnesty have not been given. The promise of an amnesty has been thrown out there, but it hasn't been followed through. So it was when Boris was doing his campaign that he suggested that he would grant an amnesty. The terms not defined. So 38 Degrees have sort of sorted out the petition to try and outline what it should entail. And an amnesty should entail specific, reasonable coverage for people who've been here for a period of time, for children, for people who have spent or suffered adversity. But they haven't been decided. All you need to do is sign the petition so that they grow their numbers and have leverage as a lobbying group. Commonwealth, no, no, no. You need your visa. Your family need their visa. If you've overstayed and you're caught, don't say, I'm a Commonwealth, I've paid this amount of money to this group. They asked me to sign this thing and I've got this certificate, fake certificate. It will not help you. You'll be deported, my dears. Please do not listen to them.
As a Commonwealth citizen, are you saying a Commonwealth citizen basically
you don't have any additional
any
privilege
or rights in the
Why?
United
No,
Kingdom?
of course not. There is a historic relationship that happened from colonization, but that is long gone.
But the Queen is the chair of Commonwealth countries.
And she loves all of her people in her Commonwealth, but she's not granted anybody a free visa. No.
To the UK?
No. There are other people that run online schemes that we've seen that have paid thousands of pounds to people who are actually wanted by the police. They have paid this money out on the false promise, been issued emails and documents to go and swear affidavits, go and swear statutory declarations denouncing their citizenship.
It does seem
None of those
have
things
benefited.
are actually legal.
It does seem that some have benefited from such programs.
Who?
I don't know.
It's not
but
possible.
If not, how do
These
people
declarations are false. The only people benefiting are the criminals that are behind the operation. By they're benefiting financially after innocent people have paid them. We've met so many. What we would ask people to do in this circumstance is report to the police. Report who you've emailed to, who you've paid to the police, because it's a fraud against you. The other thing is people need to stop doing the stateless applications. Many unscrupulous lawyers suggest people just put in an application, just put something
that you're
in
stateless.
that you're stateless. When you've been given a visa to come here, or you've claimed asylum, or you've put in a previous application, How can you now come and say you're stateless?
Turn around to say you're stateless.
Exactly. But because people again just think, oh, the lawyer's putting in an application for me, they thrive on this false hope.
But what about the roles of lawyer themselves in this matter?
Lawyers are supposed to be ethical. So your lawyer should be acting in your best interest, giving you a client care letter, fully qualified and experienced and insured. And if the lawyer is not fully qualified, experienced or insured, you should not be using them. And if it's a person who is an immigration advisor, check that they're registered with the OISC and make sure that they equally have insurance. If they don't have these things, please do not fall to be one of their victims, and go onto the Law Society website or the OISC website and get people who are registered and qualified in the correct manner.
All right, fantastic. Jennifer Obaseki is the senior partner at Obaseki Solicitors, legal firm here in the United Kingdom that has been involved in immigration matter, business and property development matters, and all matters that's got to do with long life development in the United Kingdom. You can actually reach Jennifer Obaseki on the number that is on the screen. Better still, you can get in touch with your Citizens Advice Bureau, or just get a good registered legal advisor or solicitors that can deal with the case. But do not do DIY. I can imagine people dealing with matters of life and death about the stay in the United Kingdom, claiming they can fill the form themselves and send it to the Home Office. You are not qualified to do that. What does it take you? What does it cost you? Get a good lawyer, let them do it for you. Why do you have to waste your life? After 10 years in the country, people still say, look, I'm going to get this done by myself. How much would that cost to get this sorted out, and they do DIY and waste their own?
The cost of the applications is scary. It's one of the things, again, you need to be asking your MP, asking your community leaders to help you put forward to your MPs, because as a family, if you're putting in the application, Home Office fees, £811, NHS fees at £500+, even up to £600 per person, even children. So it's very, very arduous on families.
Fantastic. This is how far we can go on Voice today on the program. My name is Tunde Alabi. It's been a pleasure to have you join us on the program. Keep watching this space every Saturday, and we'll be bringing you more information on legal matters to members of our diaspora community in the UK. Enjoy the rest of your evening. If you do have any query, do not hesitate to get in touch with us. But stay out of trouble. Do not DIY your future. Get a qualified solicitor. Bye. Part of our continued efforts to reach the African and other ethnic communities in the United Kingdom with greater impacts, and create the platform to hear your silent and unheard views in this hugely growing community in the United Kingdom, our channel Ben TV presents to you another live current affairs television program. Our focus on the program is to review and discuss issues around the diaspora community in the UK. The program offers you that unrestricted voice on issues affecting you in the UK. Join us live every Monday at 10 a.m. to 12 noon. Another business segment of Dialogue in Diaspora, 2 to 3 p.m. every Monday. But guess what? You know you can be part of the program. Just send us an email at bentelevisionuk@gmail.com. Dialogue in Diaspora, your voice, your opinion on our TV.